The Second Amendment states a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. That seems to be something that the U.S. Department of Justice is trying to reiterate in their most recent correspondence with the state of Virginia. Several weeks ago, Virginia's lawmakers sent the governor there gun control legislation, including a ban on certain types of semi-automatic firearms. From the DOJ, Assistant Attorney General Harmeet Dillon sent a letter to Virginia's governor stating several things. She says just last year, the U.S. Supreme Court made clear in a unanimous opinion that the AR-15 is both widely legal and bought by many ordinary consumers. Unfortunately, Dillon said, Virginia appears poised to infringe on the Second Amendment rights of law-abiding citizens to enjoy and use AR-15 rifles for lawful purposes by making it a crime to purchase and sell them. Dillon went on to say in a letter to Virginia's governor that this Civil Rights Division will seek to enjoin any attempt to infringe the right of law-abiding Virginians to acquire constitutionally protected arms that are possessed by literally tens of millions of Americans. Now, the Department of Justice has intervened in some cases across the country, in particular out of Illinois, with the challenge to the state of Illinois' gun ban that was enacted back in 2023. Just recently, the DOJ filing in the federal judiciary support for plaintiffs who are challenging the law that says the guns are not to be sold or possessed, and that is unconstitutional. That case still pending in the federal judiciary. But Dillon's letter to Virginia says that we are aware the Virginia General Assembly has forwarded you several bills that, if enacted, currently written, it would mirror the unconstitutional restrictions struck down in Heller 18 years ago, pointing to previous U.S. Supreme Court precedent. Dillon also went on to say, I urge you to reconsider allowing any bill that would infringe on the lawful use of protected firearms by law-abiding citizens to become law. She said the Second Amendment rights of law-abiding citizens shall not be infringed. Now, all of that happening in Virginia while the federal judiciary's handling several cases challenging gun laws, including several cases still pending before the U.S. Supreme Court, dealing with restrictions on who can have them, where they can have them, and what types of firearms. But in Rhode Island last week, the House Committee on Judiciary tackled several gun control bills and also heard from several opponents of these measures. We'll start here with Representative Boylan and Tansey with separate bills from each was presented at the Judiciary Committee in Rhode Island last Wednesday.
I'm again introducing this bill, H 7035, that would limit firearm purchases to one gun purchase per 30 days. Laws limiting the number of firearms a person can purchase within a certain time frame help reduce the number of guns that enter the secondary market, weapons that are more likely to wind up at the scene of a crime. Currently, 5 states, Virginia, California, Maryland, Connecticut, and New Jersey, plus New York City, limit bulk gun purchases, a policy that has been proven to reduce gun trafficking and consequently gun violence. The bill would require a firearms training certificate issued within the past 5 years to purchase any firearm, to include both handguns and long guns.
If these weapons are too dangerous to be sold in Rhode Island, then we really should have addressed possession at the same time. We didn't, and this bill corrects that. This bill is narrow and targeted. It does not expand definitions. It applies only to firearms already covered under Rhode Island law. It simply addresses one word, possess, while also expanding the amount of time for individuals who currently own these weapons to come into compliance by selling or transferring them lawfully.
So the legislature looking at bills, one to say you can only have one gun a month. The sponsor of that said, well, maybe we make it 3 guns a month to answer any kind of constitutional challenge. Also expanding Rhode Island's blue card for requiring that for any kind of purchase, not just handguns, but also long guns. And then you get that last bill that was brought up about changing a word of possession based off of previous legislation that Rhode Island passed last year. But that's not all. Rhode Island also heard about a variety of other things, wanting to ban anyone under the 18 from owning firearms. A measure called the Firearm Responsibility Act that could lead to higher prices at the gun store. Another bill requiring shooting ranges to have warnings and staff training about the signs of suicidal behavior. But there was a variety of others that were raised, a lot of opponents there to question the costs and the enforcement about all of these measures, including one that would require liability insurance for firearms owners. But you had two individuals, John Francis, owner of Competition Shooting, and Kara Tibbetts, oppose all of these measures and more in front of that Rhode Island committee.
When the assault weapons bill was proposed last year, the governor and people on this committee stood in front of the cameras and said to the Rhode Island public that, hey, take a breath. No one's coming for your guns. No one's taking anything away from you. You'll be able to keep what you own. You just won't be able to buy any more after the law goes into effect. Well, no, here we are. Now you want to take them away. I mean, that's like a bait and switch, is it not? People have spent untold thousands of dollars buying this stuff, and you wrote in there that they can transfer it to someone in a state where it's legal, or they can sell it to a store like mine, or they can turn it over to the police. I can tell you unequivocally that I and no other gun dealer in the state is going to pay a dime for these guns, because what am I going to do with them?
These bills won't stop criminals. They will only endanger law-abiding women like me who simply want to protect ourselves and our families. The hypocrisy here is a little bit shameful. Just last week, this same committee heard at least 10 pro-criminal bills to wipe records, slash waiting periods, and make it easier to expunge multiple felonies. You were eager to give offenders second chances. Yet today, you attack honest citizens who obey the law. Rhode Islanders are tired of it. We do not want the government involved in every single aspect of our lives. We just want to be left alone to defend ourselves and live free.
Again, you can see a variety of individuals there in the background wearing those yellow shirts, signifying that they were in opposition to these bills and more. The committee heard from other residents, including Jonathan Barrett, Ross Mayer, and Morris Devine during Wednesday's committee.
By simply adding the word possess, this bill turns thousands of law-abiding Rhode Islanders into felons after December 31st, 2026, unless they surrender or sell their firearms, which would be at a great loss. They bought them legally under the old rules. This is not regulation. This is retroactive confiscation. Our own Rhode Island Constitution, Article 1, Section 22, could not be clearer. The right of the people to keep and bear arms shall not be infringed. These bills all shred that right. Worse, none of these are going to stop the criminals.
As offensive as I may sound, I respectfully remind the supporters of these restrictive bills that the purpose of all, if not mostly all, of our constitutional amendments is to restrain government and to protect the people from their own government. Yes, the very tyranny and the tyrants that our founders warned us about. However, history also shows us that both tyranny and oppression begins with the inability to defend oneself, or rather when that ability to defend oneself is impeded. So let us not inch any closer.
So my big question is, what will you do when law-abiding citizens that own their property, that intend to retain it, because under the takings clause you're not providing anything in the way of relief, what are you going to do? Are you coming for them? It can't be a secondary concern because it's a felony.
Thank you, sir, for your testimony.
Thank you.
Any questions of any of these witnesses? No clapping. There'll be no clapping, please. Okay, thank you.
Now, clearly, this is an issue that the judiciary has to tackle. There are several cases in front of the U.S. Supreme Court that asks that question. Could states ban certain types of firearms? Whether or not they take those cases and whether the Department of Justice has any sway over the direction of the Supreme Court's decision, something that we'll be monitoring at thecentersquare.com.